Welcome to People Want to Know, an immigration segment where we take your immigration questions, and I have none other than attorney Jessica Dominguez here to answer them. Thank you so much for joining us.
It's my pleasure, mijo.
This week we're going to go over a question that we've been receiving from so many of you, and we're going to get right into it right now. The question we received is from Artemio in Illinois, and he writes, "My son is a U.S. citizen, and he is over 21 years of age. Am I eligible to receive my residency inside the United States?"
This is a question that we receive often. And the reason for that is because we have thousands of parents who have sons and daughters who were born in the United States who are over 21 years old, and these parents want to know if they can qualify for legal permanent residency and adjust their status here in the United States. JP, many of them know that because they have resided in the U.S. for over a year without a legal status, when they leave the country, they get what's called the 10-year bar, a 10-year punishment. This is why they want to know if they can get their status here in the United States. Today, I will share 3 of the exceptions that can help a parent get their legal permanent residence here in the country. 3 exceptions under the law that could allow them to seek their adjustment of status.
Great, so why don't you do us all the favor and share the first way?
The first way would be for those who enter the country with a visa, with a tourist visa. If they came in and their visa expired and they even stayed beyond the time that they were allowed to stay when they enter the country, they can prove that they came in with inspection and they can apply for adjustment of status here in the United States, will not have to leave the country to pay the 10-year bar or have to ask for a waiver.
Great, I know that's going to help so many parents out there that seek this information. Why don't you share with us, please, the second way?
The second way would be for those parents who have the protection of 245I. 245I is a section of law that allows these parents to get their legal permanent residency here by adjusting their status, as long as they can prove that someone filed either a family petition or an employment petition before April 30th of 2001 and who have been living in the United States on or before December 21st of 2000. They will have to pay a penalty of $1,000, but they can adjust their status here.
Thank you for that valuable information. Let's move on to way number 3.
The third way for parents to adjust their status here in the United States without having to go abroad and pay a 10-year penalty is if they came into the country, for example, with their SOL card. In the past, a lot of people applied for the Special Agricultural Worker Program and they were given a work permit. And this permit allowed them to go in and out of the country with permission. If they came in with this card and they had the permission to come in other words, they came in with inspection, they can also use this as evidence that they were inspected at their last entry and apply for adjustment of status. Now, the key ingredient here is to be able to prove that their last entry was with inspection.
Well, thank you for sharing that information. It seems all pretty straightforward to me. Would that be a correct assumption, or is there something more under there that I should be?
Well, JP, it is never straightforward under immigration law. I would suggest that anyone who finds themselves in this situation, any parent who has a question, let's just say today they found out, okay, great, I came in with a visa, my child is over 21, I should just go ahead and apply for my adjustment of status. My advice to you would be that before you apply, that you see an expert, someone who can analyze your case, because there are other issues of inadmissibility that must be analyzed. For example, did you have a tourist visa and you used it to come in and out of the country even though you're already residing here? That would be an issue of inadmissibility because you could be given a charge of visa fraud. Have you been arrested for any crimes? Before you apply, all those issues must be analyzed.
Well, there you have it. Seek the opinion of an immigration expert in your area to see if there's any other factors in your case. Thank you so much for joining us, Attorney Jessica Dominguez. Thank you guys for joining us. And we'll see you guys next week on People Want to Know. And please, keep subscribing, keep liking, keep sharing, because we can only do this with you guys. Thank you so much, and we'll see you next week.
Hey guys, wait, don't go anywhere.
There's more videos for you to watch down here.